Hi, if you are participating in the Lobbyist training session today, we will begin in approximately 15 minutes. Thank you. Hi, we are just performing a few last-minute tests here. Thank you for joining us. We will begin here shortly. Thank you.
Okay. All right, can y'all hear me okay? Okay, fantastic. All right, today is the October Lobbyist Training. I appreciate your being here today. And for those of you who are attending by webinar, we do have a number where you can text questions to us. The format will be that I will address the questions at the end of the session, and I'll reserve some time at the end of this for questions in case anybody has any. I expect it'll take maybe an hour. Usually it takes a little bit less than that. As I work through this, especially since we've got a small group here in Montgomery of 6 people, if you have questions that you want to ask, this is a good format, in which to do that. So just throw up your hand and ask questions if you have any. Do any of you lobby in other states? Okay, if you do, so you've been through this training. Now, where have you been through the training before?
West Virginia.
Okay, anywhere else?
We don't have one in Mississippi. Nevada.
Okay. Do you have any, do you lobby on the federal level at all? Okay. The thing to remember is that most states approach this about the same in terms of what's allowed and what's prohibited. So nothing that we talk about today should be too different from it. But because you have lobbied in other states, it would just be kind of interesting if there is a difference in another state's approach for you, at least mention that. I try to keep up with that. Unlike some other jobs, this one really doesn't have a network of people who speak that often together. I mean, we do gather kind of once a year. There's some publications that kind of alert you what's going on in other states, but certainly it's not to the extent like lawyers groups or even your own groups probably talk about some of these issues. So I'd be interested in what some of the differences may be. Remember this about the presentation today. Everything that we go over is the minimum standard. So if you want to exceed the standards, you are encouraged to do that. But this is the ceiling. I mean the floor, not the ceiling, in terms of ethical compliance. And nothing we say in here in response to questions you may ask give you any kind of legal protection from prosecution. Although there is a process for doing that we will talk about in a few minutes. There have been some highlighted prosecutions in Alabama which have kind of made ethics a central point of discussion in many parts of the state. Former Speaker of the House was convicted a few years back, and his case is currently on appeal to the Alabama Supreme Court, and so we're all kind of waiting to see what the Supreme Court may do with the ethics laws. But in terms of the average citizen in Alabama, it's been in the press a lot at the state, county, and at the local level. And there have been prosecutions of individuals from corporations who have interacted with elected politicians too that have made the news. So the relevance of that to you is that there is a bit of a heightened awareness about what is covered under the Act and what's prohibited, and there's a lot written about it in the state. So just know that the environment in which you're going to be working is something that over the last 4 years has had a great deal of attention brought to it, primarily by those who have been accused of violating the Act. What I have found that means is that your average citizen, or those who care enough about this issue to kind of tune in, now understand terms like thing of value, and they understand better than they might have 5 years ago what's allowed and generally and what is disallowed generally.
The webinar said that there's an echo. I don't know the echo.
Okay, thanks. Apparently there's an echo. Is that just from one person or multiple?
It's just one person.
Okay.
Okay, go ahead.
All right. I apologize for the echo. There is very little that I can do about it as far as I know. If anyone on the webinar cannot hear me, though, or if the sound goes out, please let us know that too. We do have a website. I encourage you to go there and look at it, because not only do we have all of your registrations on there, your disclosures on our website that are accessible by the public, but we also have information that might be relevant to you. For example, if there are events which have been pre-certified by us as not being violations of the ethics laws, your widely attended events or your educational functions, social functions that public officials may attend, those are also published on our website. So you may be interested in someone else's event, and if you are, you can access that through our website. The other point is that the average citizen has access to these documents through our website too. Our commission is, and this slide is out of date. Our commission is made up of 5 individuals who were appointed by the governor, lieutenant governor, and speaker of the House to serve staggered 5-year terms. And their makeup changes annually, and we generally have somebody rolling off and somebody coming on. Our commission chair right now is not this individual, but is this individual, Charles Price, a retired circuit judge from Montgomery. We also have Beverly Brady, who is a lawyer from Auburn, Alabama. We have John Plunk, who is a lawyer from Athens, Alabama. Former Chief Justice Lynn Stewart from the Alabama Supreme Court is a new appointee to our commission, and our newest commissioner is Stan Mcdonald. Mr. Mcdonald is a lawyer in Huntsville, Alabama. So you've got 5 lawyers on there, a retired circuit judge, and a former Chief Justice of the Alabama Supreme Court serving. Unlike some states, our commissioners are not partisan. I know in Florida, like you have a Republican commissioners and you have Democratic commissioners who identify with the party, but in Alabama, by statute, our commissioners cannot engage in politics at the state, county, or local level of government. We do have an advice or opinion process that you can take advantage of. We can answer questions for you either informally or formally. Informal opinions are probably far and away the most that we give, the largest way we give out advice from our office. We this year are on track to give out over 1,000 informal opinions, which is up dramatically from previous years. Every year, though, since 2015, we have gone up in the terms of the informal opinions that we give. Informal opinions, however, do not give you protection for prosecution. Only a formal advisory opinion can do that, and that is by statute. A formal advisory opinion is a document that is actually voted on by our commissioners, and according to the Code of Alabama, if you request one and receive it, or you are in a materially similar circumstance to the requester, then you are given protection from prosecution for relying on that opinion. So the question always comes up, well, who should request a formal advisory opinion and who should request an informal opinion? Most times an informal opinion is certainly from y'all, is going to give you what you're looking for. Because usually what lobbyists will ask, or it's a variation of, what do I need to do if I failed to get in my amended form for a new client that I've brought on? The answer to that, even though it's an informal opinion, will refer you back to the code that says that you've got 10 days to update your information. However, we want you to comply, so I'll tell you to contact Vicki Manning and to talk to her about updating it. Or if you've got a disclosure you've got to make. Let's say that you have expended more than $250 on a public official or a member of their household within a 24-hour period. You are required to disclose that under Section 19 of our Act. However, if you disclose the wrong amount, you might call us and say, what do I do about that? The same answer will be, I will tell you to contact Vicki Manning and file an amended disclosure. So the recurring theme for y'all on those kind of issues is the answer is going to be Vicki Manning. I'm going to tell you to contact Vicki Manning in our office, and that's her job. She's our lobbyist liaison, and her job is to help you through this process. She is not the one who in our office who is going to fuss at you for not getting it in. She will tell you how you can get it in, and we really want you to comply. So don't be shy about saying that you filed something incorrectly or you filed the wrong amount. The worst thing that you can do is not amend or just not disclose it to us. So if you go back to some of the earlier slides that I showed you, because of the focus in this area that has been generated by the prosecutions under the Act, and also because of the accessibility that our website gives people, we have had questions asked about, well, so-and-so had an event, and they paid for rooms at the Grand Hotel, and the rooms that they paid for were in excess of $250. Why haven't they disclosed? What that will generally do is generate a follow-up from our office saying, you had an event that was pre-certified, If you have any expenses to claim over $250 in a 24-hour period, make sure you do it. Most people have an explanation for why they didn't. They said, well, we didn't spend that much on them. And some people we have had said, yep, I forgot to do it. And so they've contacted Vicki, and they have disclosed it at that point. So Vicki's going to be the one you go to for that. We have had lobbyists, or more, I guess, accurately, the companies that hired the lobbyist have questions about whether someone should register as a lobbyist. And that has required us to look at the definition of lobbying to see if the individual fits within that definition. So if we're saying that they do not have to register as a lobbyist, that might be an opinion that you would want to get in a formal advisory opinion, because your failure to do it is punishable under the Act if you're lobbying without having registered. And so you might want that kind of protection. Or if you want to know about whether something may be considered a thing of value, that would require us to apply the definition of thing of value in the code to your particular set of facts. Again, that's something you might want to request in a formal advisory opinion. We are likely to tell you that, though, on the front end, because we really don't want to give opinions informally in an area that we have not spoken to formally before, unless it's just very clear from your facts and from the language of the code what the answer is. Okay? So any questions about the informal opinion process or the formal advisory opinion process? The formal advisory opinions have to be voted on by our commissioners. They meet every 60 days. So that also generates a lot of informal opinions. You just really can't wait 60 days for the opinion to get generated from our office. Yes, sir?
What are the deadlines for, how many days in advance of the meeting?
Request for formal opinion. We don't have a deadline in our administrative rules. It's really, if we can get to it, then we'll make every effort to get to it. It's likely that we may pass an administrative rule that sets some kind of deadline, but I still expect that if we do that, it's going to be a pretty close deadline of like 14 days out. Now, the caveat to that is the rule will probably also say that we don't have to give an advisory opinion, and so if we can't get to it, that we're not. But I think that just given what I've seen since I've been here, we have a fair number of people who have asked 2 weeks to a month out, and given our agenda, we didn't have much going on. It was really easy to turn around an opinion. So I hate to set a deadline that we're then constantly ignoring because we can get to it. So I'd rather set it a little close, with the caveat being that we might not address it if we've got a heavy agenda. So what's the deadline in other states, if you know?
Most actually don't have a
Yeah.
deadline in this.
Yeah,
We also will roll them, so it's like if I don't make it to that meeting, we'll roll them.
and we do that too. And sometimes we will kind of work on a formal advisory opinion with the requester and with other interested parties too. I mean, it may be an issue that the Attorney General's office has a kind of an interest in, or we want to make sure we're not kind of overstepping some other areas of law, or there may be kind of embedded within your question a conflicts of law issue that's not really us as much as it may be an Attorney General opinion. So depending on the question asked, we'll collaborate sometimes, or we'll defer, and the requester may ask the Attorney General for an opinion about a portion that relates to them, and then we'll pick up ours. Some other states sometimes, though, will treat their advisory opinions sort of like administrative rules, and they'll post them on their website and allow public comment for 60 days. We generally don't do that. However, if we self-generate an opinion, in the past, we have left that open for public comment, and we've done that by notifying people on the website and also in our meetings that we're inviting public comment. When we have done that, it's been on an issue that usually the folks who would comment anyway kind of have an opinion about, but because we're self-generating the opinion, it kind of loosely mimics the administrative rule process, so we've tried to adopt the same recognition of a public comment period in that. It's a lot more than what you asked, but maybe that's helpful to somebody. The opinions have to be prospective in nature. We can't give advice after the fact. So if you've got a question, think about it well ahead of time if you can. If you have already done it, it's just kind of unsatisfying for both sides because we've got to tell you we can't really answer that question. And so good luck. I mean, that's basically the the point that we get to. So think about these issues well ahead of time if you can, and just know that we're more than happy to answer the questions that we get, as long as they're prospective. Informal advice is also confidential by administrative rule. That's a bit different than some other states. North Carolina has that provision, though, and that's where we got that. And if you think about it, having confidentiality attached to the informal opinions encourages people to ask questions ahead of time, and we don't want people to feel like they can't ask for guidance ahead of time if their point is to stay out of trouble. So we do want to encourage that. However, you can waive the confidentiality, and we generally have had people, when it's become an issue, those who have requested the informal opinion have waived the confidentiality and disseminated the informal opinion, but we can't talk about it. Okay, so any questions about that? Okay, the complaint process. We are primarily a probable cause board, and that's not too different from what a lot of other states do. But if there's a violation of our act alleged, then our staff will investigate that, and if we believe that there is sufficient evidence of a violation, we will present that to our commissioners, who will sit sort of like a grand jury and weigh the evidence and determine whether it is more likely than not that there's been a violation. And if they find that there has been one, then they will refer it either to the Attorney General's office or to the appropriate district attorney. But they all start with a complaint, and we have to have a written complaint filed in our office based on credible and verifiable information. Where lobbyists are concerned, we don't get a ton of complaints against lobbyists formally. We do get a lot of complaints during the session that y'all are over there not having registered with us, or that you're lobbying for a client that is not reflected on our website. And the response to that for y'all needs to be to follow up with your principals and make sure that they have done what they're supposed to do to verify that you're out there representing them. But there's not a session that goes by that somebody doesn't call over here saying, I've looked on your website and so-and-so's not registered as a lobbyist, but they're over here. And we'll say, well, you can file a complaint, and then they generally don't. The other thing you need to keep in mind is that under our act, there are certain transactions that are prohibited between lobbyists and principals unless they fall within an exception. The transfer of a thing of value, which generally is something that has monetary value attached to it. But if you're a player in that and you offer something to a public official, then you potentially could be caught up in the prosecution for that violation too. There are examples of people, not many, but there are examples of people who on the other end of that transaction, those who have offered things to public officials having been tried and convicted for those violations. So it is out there and it could happen, but just know that the complaint's got to be filed with us and based on the criteria that I gave to you. Complaints are confidential in our office, so if one's been filed against you, you don't have a right to know who filed it. And at the same time, if you file one, the person against whom you have filed it doesn't have a right to know who filed it. We cannot disclose the contents of a complaint until after the matter is completely concluded. As a general practice, we don't talk about them anyway. Certainly not about the evidence that's in a case. So there is confidentiality that attaches to them. We have to complete investigations within our office within 180 days. However, our commission can grant an additional extension of 180 days. So the most or the longest that a complaint can be pending in our office is 360 days. Statute of limitations for a violation of our act is 4 years if it's an intentional act, 2 years if it's something else, if it's a lower degree of culpability. And their intentional violations are Class B felonies, meaning that you can be punished by up to between 2 and 20 years in prison for that violation, and a hefty fine, and misdemeanors punishable up to a year in prison. But we also have extensive fining ability and authority within the commission itself. We can issue fines up to $6,000 per violation if they're approved by the district attorney or the attorney general. But they've got to be approved by one of those two before we can issue a fine. But we do issue a fair number of fines from our office. So any questions about the complaint process statute of limitations, punishment ranges, any of that. Overall theme of the act is that you cannot, a public official cannot use their position for personal gain. Where y'all are concerned, you need to understand that the prohibition that applies to you can be found in section 5.1 of our act, and it's the section that prohibits the transfer of the provision of a thing of value to a public official or employee or a family member of the public official or public employee. And you should know that the family member of a public employee is their spouse or their dependents. However, for a public official, those members of the legislature, the governor, anybody who's appointed at the state, county, or local level, their family members include their spouse and dependents, or their adult children and their spouses, their siblings and their spouses, their parents and their in-laws. So it's a wide group of folks. So if you have a question about whether someone is a family member of a public official, then you can look at the statement of economic interest that is filed, and that will disclose some. However, you can always ask the public official too. Just know that for a public official, it's a much bigger group than it is for a public employee. Any questions about that? The other part of our act to be aware of, and this you would already know even if you didn't walk into this room, nothing can be given to a public official or public employee for the purpose of corruptly influencing their official action. And that does not matter how much it costs or what its value is or what it is. Nothing at all can be given to a public official or a public employee or a member of their family to corrupt their official action. Okay? Any questions about that? If I've mentioned anything so far that you have not found in any of the other states in which you lobby, it's all pretty.
I mean, some of them don't have the, I can buy a meal or a cup of coffee in some states. I read yours, it's like, I can't buy a meal or a cup of coffee.
Well, you can.
Okay.
You can. There are.
Well, you're tighter than some.
Yeah, it's funny that you mentioned that, though, because if you think about like South Carolina, which everybody offers as the no cup of coffee state, it's not even really that. I mean, because it's got exceptions even to that exclusion. Ours has 18 exceptions to the general prohibition. However, other states do view us as a no cup of coffee state. But I will tell you that you can certainly buy a cup of coffee, because for lobbyists, there is a food allowance alone of $25 per occasion with an annual cap of $150. So you can buy meals, but it's limited. But that's just straight meals. You also can provide hospitality and meals as part of a larger function, like a widely attended event or an educational function. Some states refer to the widely attended event as a widely attended gathering, but they're all about the same thing. It's a collection of people with diversity of views. Alabama has the requirement that you must have at least 12 people in attendance. But your takeaway from this should be that there are limited allowances for interactions. And if you are not comfortable where those are, even when you leave here today, you can certainly ask us what those limits are, and that's an informal opinion, and we can give that to you. Or you can access the pre-certifications on our website, which show other events we have said comply with the act, and you can see what other lobbyists or other principals are doing, and that's a resource for you too. You can access those, see what we've approved, see the questions that we've asked, and structure yours consistently with that.
You want to group environment, does that, so Nevada is a no coffee state, and, but they have an exception where if I invite the entire committee.
Right.
But yours is 12 people, but does the 12 people have to be members?
The statute itself.
The audience can, they can hear the audience questions on the webinar if you're working.
Okay. The question was whether it was a general discussion of, in other states, the membership required for a widely attended gathering is specified within the statute or either by administrative rule that you can invite everybody from one office, one executive branch office. And the question was whether ours was similar. Ours does not. Ours simply says there must be a diversity of views expressed. And it must be at least 12 people in attendance. And that number 12 was arrived at politically when the act was passed. And I think the number came from the size of the minority caucus in the legislature. So it was tied to that. I mean, the idea was that that smallest group ought to be able to, to have a gathering. So they at least wanted to make sure they could all get together. I think by administrative rule we could certainly flesh out that, but I will tell you that most of the widely attended gatherings look very similar to what other states recognize as being required for their widely attended gatherings. You will have, the health committee invited, and every member of the committee is invited, or you'll have two committees, one from the House and one from the Senate, invited to it, or you may have a group of 35 or 40 people, and we just kind of make the assumption that, given that number, that there are diversity of views expressed, and the widely attended gathering is used most often for legislative receptions, where you've got like 500 people invited, the entire legislature invited. Although we have had kind of some odd requests that otherwise, satisfy the definition of widely attended event, most of them are for fairly large gatherings where a whole bunch of people from different officers are invited, so it's just not something we've really had to get into too much. But I've seen that on the federal level they do that. They say, the guidelines are that you can't have everybody from finance invited, or you can't have whatever. But no, ours is not spelled out that well.
So, just to clarify, is yours invited or attended?
You have to. The question is whether our statute requires that 12 have to be invited or actually attend. The statute says you must reasonably expect that at least 12 will attend. Most people are inviting more than 12 people. And look, I mean, we know that you can't predict the future, but where it would be a problem is if you asked a group of people that facially could not attend. And I don't even know exactly who that would be, but let's just say that, you invited 13 and clearly 12 of them could not attend, but the governor could. I've not gotten that request, though, to be quite honest with you. What I have told people is that I feel a lot better about okaying an event where there are more people invited rather than less. If your number's 12 and you reasonably expect, and that's what you tell us, you reasonably expect 12 people are going to attend. Absent evidence to the contrary, I'll take your word for it. However, if you invite 15, 20, 25 people, then it's much easier to say out of that group you should reasonably expect at least 50% attendance. But look, I also know, having been around long enough, that you don't always hear back from the legislators you invite. You might invite the entire House of Representatives and no one RSVPs. So I know that happens too. And so if your event is otherwise going to satisfy the requirements for a widely attended event, then we'll give you the benefit of the doubt on the numbers that you reasonably expect, unless there's obvious evidence to the contrary. Yes, ma'am.
I am married to a public employee. He works
Okay.
for the state. Does this affect what do I do about that?
All right. So there's somebody in the audience who is married to a public employee and wants to know if any of this that I'm talking about affects her and her family relationship. Yeah, the short answer is no. Okay. I will go back to that one statement that nothing can be given for the purpose of corruptly influencing. Okay, you can come up with a set of facts that would show corruption here, even in a marital relationship. But I don't know what you specifically may be concerned about. But the questions, I know your mind can just start running. The kind of questions I've heard from people similarly situated to you are: we have an account, a joint account, and what if I spend money out of it on somebody and I don't know that they're married to a public employer, all those kind of things. I just can't really tell you anything to make you feel better about that, except to say this: intent matters. Intent matters under our act and to everybody who prosecutes this. And we can come up with a list of horribles if we wanted to. But in terms of your transactions with each other, there's going to be a family exception that's going to apply to it. Most of the things you're probably worried about that I have had people come up with really aren't going to be concerns. Anyway, we go out to dinner together, and I've got a separate checking account, okay? And I would look to see whose money it is, that's paying for it. If your principal's paying for that, and they're using you as a funnel, I mean, again, we could come up with facts that would be bad, but
We're very boring people.
yeah, most folks out there who ask that question are. You know, I mean, it's that if you're asking the question, that tells me a lot. You're not all that worried about it, but it's not that unusual. I also don't know what the best fix for that would be, other than just say nothing, you know, everything's allowed, or to grant a spousal exception, which I think has its own problems with it. So what I tell people is that if you've got something really funky out there, and you think, all right, even I think this is kind of close, just ask ahead of time. We have had situations where, I don't know, public officials have been really, really good friends with the lobbyist, and it predates, and that's not really what you're asking, but their relationship predated the time that anybody was a public official or anybody was a lobbyist. And now they're up here, somebody's in the legislature, somebody's a lobbyist, and that lobbyist is paying for something, like a portion of the child's education, something that was started before they ever really kind of got into this position. We've been asked that before. And you know, once that history is explained, and if it predates service, and it's clear that it's not motivated by the professional relationships that you've got, that goes a long way too. Disclosure helps a lot here. If it's a closed situation, I would say disclose through some form, or at least have some discussion with us. Is that helpful at all?
More or less. I lobby
Right.
for a nonprofit, so we don't do anything. But,
Right.
I mean,
Right. You know, if you had, I don't know who else you work with, but if you had some issue that was before, let's say you were married to a legislator and there was something before the legislature, then, you know, your spouse would probably have a conflict of interest possibly that they would have to be mindful of during the session when things are going through. You know, somebody else might need to be point for them. If they were sending you into the State House to have, you know, contact with your spouse, who, like maybe was a committee chair or something, then that could be an issue for both of you. But most of these are situations that can be worked around with, you know, excluding yourself from certain actions, or allowing somebody else who, you know, maybe working with you to take the lead or something. But again, just have dialogue with us about that if it comes up. Any questions about that? Okay. There's also a de minimis allowance. Anything under $25, that's per item, with a annual cap of $50. So you've got really two that we refer to as de minimis allowances. One is for food and one is for items. You've also got something that's not specifically addressed here, but if it's a promotional item that's given as part of an educational function, say you are a lobbyist for a municipality in the state, and you have a educational event in that town, and your client wants to give a quote swag bag with promotional items for your municipality, a bottle of water that's got the logo on it, or if it's at the beach in the summer and you've got a pair of, you know, cheap Wayfair type sunglasses in there that have, you know, the corporate logo on it, or something. Those kind of promotional items. There's an exception for those two within. So there are several exceptions in there that would apply. The main ones that you're going to talk about or hear about, that you'll hear about from our General Counsel Cynthia Ralston, who's about to get up and speak. And those are your educational functions and the like. So at this time, I'm going to turn it over to Cynthia. I forgot to introduce myself at the beginning of this, and I really apologize for that, but I'm Tom Albritton. I'm the director of the Ethics Commission, and so that's me. So I apologize for not addressing y'all with that before I started speaking. And I'll now turn it over to Cynthia.
Thank you, sir.
Yep.
And to address part of your question, the definition of thing of value is really found in the exceptions, because there's 18, and there's a family member exception, so that you would fall under with your spouse. So that's where you can find the exceptions if you want to look at them. The ones that, as Tom has referenced, is educational event or educational function, widely attended event, and economic development function. This is where lobbyists and principals can sponsor an event, give public officials and public employees what would typically be considered a thing of value, but because it falls under one of these exceptions at one of these events, it is not a thing of value. Okay? So, but the definition of educational function, it allows, sorry, I think the slideshow may be a bit old, but the transportation, lodging, expenses, and fees for meaningful participation of a public official or public employee is permitted to be paid for. A widely attended event, he's already gone over that. It's 12 people with a diversity of views, which, you know, you can all be accountants and still have a diversity of views. The economic development function is any function in that is focused on economic development, and they can pay for transportation and lodging. So hospitality is comes up a lot. We have an opinion out there that says you can't, hospitality alone cannot be, it has to be an integral part of one of those functions. You can't just have a deep sea fishing trip that has no other component except you're taking a bunch of public officials or public employees on a deep sea fishing trip, okay? So it's got to be an integral part of it. There's a meal and food beverage that he just talked about, 25 and 150 for lobbyists and 50 and 200 for principals. And I'll talk about some advisory opinions regarding this as well, but this exception is independent from being able to provide food and beverage at a widely attended event, educational function, or economic development function, okay? So this is an independent standalone meal exception. So pre-certifications is also one of the 18 exceptions to a thing of value. If we pre-certify, we being the Ethics Commission, if we pre-certify an event, then whatever's provided is not considered to be a thing of value, okay? Typically what we pre-certify, and I think in almost all circumstances, have we ever pre-certified anything that's not one of those functions? Okay, so almost always it's a request and they outline what's going to be happening at their widely attended event, their educational function, or their economic development function. And we will say, okay, because you have met all of the qualifications, then what you're providing is not considered a thing of value. It's an exception, and therefore the public officials and public employees attending that event can do so comfortably and know that they're not going to violate the act. Okay, we do not have to pre-certify your event in order for it to comply with being an exception to the thing of value. Does that make sense? Right? So just because you don't have a pre-certification doesn't mean there would be a violation. Pre-certifications have to be requested more than 10 days before the event. We have an administrative rule that requires that. So if you ask for it 9 days before, we're not going to be able to pre-certify the event. But again, it doesn't mean that it's not permitted. So in order to be pre-certified, the educational event has to be a meeting, event, or activity organized around a formal program or agenda, which most, if it, all conferences are, has educational or informational speeches, and it's concerning a matter within the scope of the participant's official duties, right? So I might not need to go to an accountant's function because I'm not an accountant, okay? So, but it would just need to be something touching on the official's responsibilities. A widely attended event has to be all of these: a gathering, dinner, reception, or other event of mutual interest. Let me say something about educational functions. They have to happen in the state of Alabama, or they have to be attended primarily by people outside, primarily by attendees from across the country. Okay, so if you do an educational function in Alabama, it can qualify as both an educational function and a widely attended event. So a lot of times if there's educational function in Destin, it also qualifies as a widely attended event. Okay, and you can get it pre-certified in that way. So the widely attended event also has to have more than 12 individuals, diversity of views, and it's not purely social, which is what I was talking about earlier. So what we're going to need is a list of the invitees. As Tom was saying, you can't invite 13 people, and the only one that can legitimately attend is only one person. If it's under 50 people, a sign-in sheet required after the event, and how many people you expect to attend. We're also going to want to know what you're paying for. You can do actual and necessary transportation expenses, but we want to know what kind of transportation is it, where is the lodging, whether you're waiving registration fees, and are they a public official, public employee, or the spouse of either. And what is the public official or public employee doing at your function? They're a speaker or panelist, performing a ceremonial function, or it's appropriate to the performance of his or her official duties. This is all pretty straightforward. Okay, integral part of the event is if it's part of the schedule, if it's on the schedule, if it does not conflict with any educational offerings that you have at the time of the conference, if all of the invitees are able to attend, that brings it to be an integral part of the event. If you have it the day before registration begins, and only a few people are invited to attend, a few select public officials, that's not going to end up being an integral part of the conference. Make sense? Okay. So I said 10 days, that we have them published on our website, the pre-certifications. So once you give us a pre-certification, we enter it on our website. Everybody can see who's invited, and whether or not those people attend or not. The invitation list is still on our website, and then what we've pre-certified. And oftentimes there's a big pre-certification stamp. That is still how we do it. And it's, approved, denied, and there's sometimes caveats listed on there. Tom will say, so long as, and there's some, handwriting about parameters. Okay, so this is the opinion that we said you can't stack. Okay, so if you've got two lobbyists that are lobbying for different issues, but lobbying the same public official, y'all can't go to take that public official out to lunch and you pay $25 and you pay $25, so the public officials gets $50 worth of a lunch, right? And you can't do that with your principal either. So the lobbyist can't pay and the principal pay, making it $75. So you just can't stack. Also, there's no de minimis lobbying in the state of Alabama. If you lobby at all, you're lobbying, whether you're lobbying for a big company or a small nonprofit, it's still lobbying. You have to register. This is you can't have a standalone event. I've covered that, but that's no, you can't just go take people on a hunt. So this is the explanation for if it's got to be an official part of the conference, either at the very beginning, the close of the conference. Everybody's invited, and it has to be sanctioned by the whoever's sponsoring the event. Okay, there can be aggregation. So if you have a large conference and there's multiple sponsors, you can put the money together and sponsor the event, but you've got to tell us who's sponsoring what. Okay, so if one principal is paying essentially for hotel rooms, we need to know that and how much their sponsorship is. You can't just have, one principal give $2,000 and somebody give $25,000 and there not be some disclosure about that. So you can aggregate the cost, but you have to tell us what you're paying for. Okay, there's a 3625 1.1 defines lobbying separately from in the definitions of lobbying. It was an additional, the legislature included it as in order to expand essentially the definition of lobbying. And so if you try to have the state, if you try to market your goods for at the state level, you are considered a lobbyist. If you're doing it at the local level, you aren't. So if you're selling goods at the local level, you don't have to register as a lobbyist, but if you're doing it at the state level, you do. Okay, selling copiers or whatever. Okay, this is you, Tom. Parting thoughts.
Any questions? Hang on.
I think we're oh.
All right, any questions about anything that Cynthia brought up? Okay, if you do have anything, just know to follow up. Start with Vicki, but Vicki is real good about getting the legal questions to us. But if you're not sure whether it should come to me or just contact Vicki. That's the person in our office you're going to have the most contact with anyway. But some parting thoughts. Remember to update your registration within 10 days. Okay. Also communicate with your principal, because the problems we have had with lobbyists and people complaining about you lobbying without registering, generally it comes down to the fact that the principal hasn't confirmed you as their lobbyist. And there is usually some drag time with that. So communicate with them first and make sure that they know that they've got to confirm you. If you have somebody filing quarterly filings for you, my recommendation is that you look at them yourselves, eyeball what's going to be filed to make sure that they're accurate. The second problem that we have had with lobbyists is when something has been inaccurately disclosed. And when that has happened, it's not uncommon for it to be the fact that somebody in the office just put it down wrong or didn't know how to account for it correctly, or didn't know really what they were supposed to do. So if it is your disclosure, make sure that you look at it and make sure that it's accurate. Remember the 10-day rule for pre-certifications because we have denied pre-certification when we've received it on less than 10 days notice, and we hate to do that. It's also unnecessary. We get that a lot less now that people are familiar with the 10-day rule, but remember the 10 days, and remember that if in doubt, ask Vicki Manning questions. So anything that you need to ask, we're a little bit under an hour. Yes, sir.
Quarterly filing question. Are we so I haven't looked at the filing, so forgive me for
Sure.
and I'm not the one filing. But is it who we met with? Is it values of things? What do you?
You've got to disclose. The question was, what do you have to disclose in your quarterly reports? What you are mandated to disclose is any transaction with a public official, public employee, or member of their household that exceeds $250 in a 24-hour period. Or also, if it is a financial transaction in excess of $500, whether you're a lobbyist or not, you have to disclose that. So those are the two main disclosures that you have to do. But if you've got a specific question, ask Vicki about it. Now, if you're in a situation where expenses are being shared among a group of people and you don't know whether your portion of it exceeds $250 in that 24-hour period, remember the advisory opinion where we talked about what expenses can be aggregated and how you break up expenses. Given your particular situation, you might need further breakdown of that. So again, ask us in an informal opinion. I think the form is pretty clear about what's got to be disclosed. Principals sometimes have questions about whether certain individuals need to be listed on their forms, but we usually handle that on a case-by-case basis. Any other questions about any of this? Okay. Well, thank y'all for being attentive. Thank y'all for showing up on the webinar. Just know that if you do have any follow-up questions, take advantage of the opinion process, and we're happy to answer them. And so I hope you have a good rest of the afternoon. Thanks. All right, and Vicki is telling me to tell you to click the continue button to submit your certification.